with Civil Petition 1/5/2020 and Civil Petition 2 of 2021. Shaukat Aziz Siddiqui versus Federation of Pakistan, Secretary Minister of Law and Justice and another.
Pursuant to the notices, कुछ किसी ने कुछ फाइल किया है? कोई आया है? जरा बताएं.
They have submitted the replies.
कौन किसके लिए है? Who's for number 1 is Lieutenant General retired Faez Hamid.
But I am appearing for response number 3 and 4.
नाम बताएं please.
Lieutenant General Faez Hamid and Mr. Brigadier Rampian.
Okay. Have you filed anything?
Yes, I filed my response to
The CMA number?
267 and 268. 267 is of Lieutenant General Faez Hamid
267.
and 268. CMA number 268.
Do you admit or deny the allegations?
The allegations have been denied. They are specific allegations. They were highlighted.
We'll come to you.
Yes.
Let's just do, as they say, homekeeping. Now, who's anybody else filed anything or no? Okay.
Yes,
And कौन रह गया? अच्छा, we had also issued notice to our former registrar. He has also filed something.
reply.
आपने पढ़ लिया है?
जी.
अच्छा, what does he say? Support or deny?
He doesn't say anything. He says, I just brought to the notice of the Chief Justice that this is what he has done.
सज्जाद साहब ने कुछ फाइल किया.
आप भी इस केस में?
Find a reply on behalf of retired Justice Qazi.
Number
253.
Okay.
254.
इसका नंबर लगवा लीजिए. अच्छा. Okay. 253. ये denial है या?
मतलब उन्होंने एक कॉपी है जिसके साथ रेलेवेंट डॉक्यूमेंट्स भी लगे हुए, लेकिन वो फॉर सम रीजन रिकॉर्ड में नहीं है.
नहीं, आपकी इसमें तो कोई डॉक्यूमेंट नहीं लगाया आपने.
जी, वो कुछ सम कंफ्यूजन मरोड, बट द रिप्लाई इज 253.
Are there some documents attached with it?
जी सर.
You are saying there are some documents attached with it?
Some documents, relevant documents, which have been attached to a separate paper book.
Where is that?
Apparently is not on the record, so we'll have to file that.
Can you give it? We'll make photocopies.
That's not part of the paper book which has been. That's not part of the paper book that has been.
We said they were left out.
रेफर किए हैं.
I don't know what they are. Let's make इनकी photocopies बना लें. इनकी कोई ऐसा करें, कोई 5 और कोई 10 बना लें. ठीक है. अच्छा, ठीक है. Now, where were we? So you deny the allegations?
Hey, Lordship.
Ansab, how should we proceed now?
Sir, it only makes my case clearer that this was a case where factual inquiry should have been held by Supreme Judicial Council. Now they are denying the allegation I made in my replies, and they have denied them. All the more reason that there should have been an inquiry in which I would have summoned them as witnesses and cross-examined them to establish what I was alleging was correct or it was otherwise. So therefore the case is very simple, that no report can be submitted by the Supreme Judicial Council before the President without holding an inquiry under Article 2096, which in this case was denied to the President. What I'm submitting, that Supreme Judicial Council cannot submit a report to the President without holding an inquiry. The report has to be based on inquiry.
What was the allegation in the Against
The
you.
allegations that he made a speech. He made a speech before the District Bar Association Rawalpindi in which he disclosed what has been going on. And in that
How
speech,
do we proceed further?
My
How would you plead your case now? What should we do?
My
If we just want to hear your point of view on this.
It's a simple case where the whole order should be quashed because it was based upon a report which was not based upon inquiry. Kindly, I take your lordship through Article 209. Very clear on that. There is no ambiguity on Article 209.
Which part of it?
So let's see the clauses 5 and 6.
Yes. Please read.
If on information from any source, the council or the president is of the opinion that a judge of the Supreme Court or a High Court may be incapable of properly performing the duties of his office or by reason of physical or mental incapacity or may have been guilty of misconduct, the president shall direct the council to or the council may on its own motion inquire into the matter. Inquire into the matter on its own motion. So now there are two ways. One is presidential reference. The other is the council may on its own motion. Now this is a case covered by the second portion, on its own motion, because the registrar was a complainant and the Supreme Judicial Council, registrar as secretary of the Supreme Judicial Council became a complainant. And on the basis of that complaint, the Supreme Judicial Council decided to proceed in the matter. So what they needed to do is inquire into the matter.
So how should they inquire into the matter?
By holding a factual inquiry on the allegations that were there.
Was any factual inquiry held?
Never.
Yeah,
That is my
This is admitted fact.
It's a fact. And they
Where is it? Is this admitted fact that no inquiry was held by the SJC?
मतलब ये जो है
Is it admitted fact or not admitted?
एडमिट कर लिया था जिसकी वजह से जो है
No, there are two aspects to it. No? One is the speech. The other is the content of the speech. So as far as the speech is concerned, he's not denying it. He said, I did make the speech, but I made it, this is their case, that since nobody was paying any attention to me, so I went public. Whether this in itself constitutes misconduct or not, that's one, leave that aside for the time being. We're simply asking you that the allegations that were leveled by the petitioner, were they inquired into by the Supreme Judicial Council or not? Is this true or false?
नो माय लॉर्ड उनकी एलिगेशन की नहीं की गई जो कि
नहीं बस ये पूछ रहे हैं. अच्छा, and now please go to what you said 2096.
Yes, sir.
Khan Sahib, you were referring to another provision.
Yes, sir. The other is clause 6. If after inquiring into the matter, so this is very important, if, after inquiring into the matter, the council reports to the president that it is of the opinion that the judge is incapable of performing the duties of his office or has been guilty of misconduct and that he should be removed from office, the president may remove the judge from office. So, sir, the council can only report if it has held inquiry into the matter.
Can you read 7 also?
7. A judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Meaning thereby, on the basis of a report which has been made after due inquiry into the matter, that only in that case, if there is a report in which he has been found guilty of misconduct after full factual inquiry, only on that basis he can be removed, cannot be removed for any other way. Otherwise, it is
going along with you, I just want to understand one thing. It's being conceded by the Attorney General that there was no factual inquiry. Now, moving ahead, what can we do? What can this court do?
That means that inquiry is that report by the Supreme Judicial Council on the basis of which he has been removed is unconstitutional because Constitution requires.
I'm not asking for an argument. I'm saying what can this court do? What if I was to ask you, okay, what sort of order can this court pass? What would you suggest?
I know declaring the inquiry, the report of the Supreme Judicial Council as unconstitutional, void, and nullity.
And suppose the allegations that you level were not true, then
What was it?
suppose that the allegations that you leveled, one person is saying no, one person is saying yes. Now we must have a mechanism to ascertain who is telling the truth. I mean, we can't throw a coin in the air and decide on that basis. So there are two possibilities. I mean, don't mind my saying so. Either the petitioner is telling the truth or is not telling the truth. There are only two possibilities. If, don't mind my saying so, if he's not telling the truth and he makes this allegation and on that and nobody ascertains, like you have alleged that nobody ascertained, and nobody ascertains whether his allegation is true or false, and is or whatever the order set aside, surely this will not be proper. That's why I'm saying, how do we go forward now?
That is exactly the case. If your Lordship may kindly see that I informed the Chief Justice of
No, we understand that. They conceived no inquiry was held. I'm saying, where do we go from here?
So therefore, the entire proceedings against me.
वो भी हो गई. Suppose, just for the sake of argument, we say, because we have to deal with these cases, it becomes precedent. Okay? Supreme Judicial Council, let's assume, did not do its job by inquiring into the matter. Correct? I think fundamental rights are available to judges as well. The due process and fair trial. By all means, hear it and then remove me. Because say this is false allegation you've leveled. You don't fit to be a judge, and not only made a false allegation, you went and made it publicly. You would imagine. If it was false, he should be removed. If it was false, he should be removed. No. If the allegation that you make now,
yes,
is established to be false after the inquiry,
yes.
Should you have been removed?
Then can be yes.
Okay.
Then
No. Now I reverse it.
Yeah.
If after inquiry it transpires that the allegation that you leveled was true,
Yes.
they may say you still should be removed because you went public. Or, no, you should not be. But your emphasis is on the fact that one way or the other, inquire into the matter. Am I correct in understanding that? Now because you had leveled initially allegations without making anyone a party. So, we wanted to hear what the persons against whom the allegations had been made, what would they say? They may come and say, yes, I did so, but there was nothing wrong in it, or simply say, yes, I did it. But the matter can't end now because they're saying, no, this is all false. So who will ascertain the truth of the matter?
The Supreme Judicial Council ought to have done that. My position is. Now your Lordship is.
जरा हमें solution भी बता देना साथ. We're looking for how to solve this riddle.
इसका simple जवाब है सर. जैसे पहले, in some cases it has happened. एक तो ये है कि जो हमने begin with
हमें सोल्यूशन हम आपका पॉइंट ऑफ व्यू समझ गए, हम आपका केस समझ गए. अब हम करें क्या ये बताइए. What sort of order which should not, either then it will amount to the same allegation that you've leveled on the other side will tomorrow complain and say You never ascertained this fact, and you held that we've done this thing. So, you know, you come up with a solution now.
Sir, my solution ये है
Yes.
sir, कि let this order of the president and the report may kindly be quashed, and a commission may be appointed to ascertain the truth, so that we can cross-examine them, they can cross-examine us.
एक second है, you know, commission. How, under what law will we do that?
This honorable court can always do so.
No, देखिए,
To ascertain the truth about the matter.
no, it can't be remanded to the Supreme Judicial Council.
Sir,
Is that a possibility or it's not?
it can be yes. It can be yes. It can.
No, I want your clear thinking on this.
After questioning the order of the president,
सब आर्टिकल 7
there is one problem which I see.
एक सब आर्टिकल 7 भी पढ़ ले
जी।
209 सब आर्टिकल 7 209 सब आर्टिकल 7 पढ़ ले
जी 7 सर वो 7 की बात हो रही है ना, तो उसमें है ए जज ऑफ द सुप्रीम कोर्ट और ऑफ ए हाई कोर्ट कैन शैल नॉट बी रिमूव फ्रॉम ऑफिस एक्सेप्ट एज प्रोवाइडेड बाय दिस आर्टिकल. आर्टिकल क्या प्रोवाइड करता है? प्रेसिडेंट कैन रिमूव ऑन द बेसिस ऑफ ए रिपोर्ट. द रिपोर्ट हैज टू बी बेस्ड ऑन इंक्वायरी. सो देयरफॉर अंडर क्लॉज 7
नहीं, देखिए,
could not be removed.
ये तो admitted fact हो गया that no one ascertained whether the allegation was factually correct or not. That much is established from what I've been able to understand. Unless somebody says, no, it's not been established. I don't think even Qazi साहब पूछते थे, Qazi साहब कहाँ गए?
उनका कोई इशू नहीं है.
Was the one way or the other, whether the allegation was true or not, was it been ascertained or not?
It was never inquired into, it was never ascertained, and if that part of the order would be carried,
How do we go forward then on this?
we are very respectfully submit.
Because, you know, both can't be telling the truth.
No, quite right.
Yes.
We are very humbly submit, my lord. The order itself may have two components, although they are mixed up. As far as I am concerned, they are mixed up in the sense, one is with respect to the public speech that was made. Whether the public speech that was
नहीं, ये मैंने कहा, that's a separate aspect.
this is what I am saying.
That may in itself be such a grave crime that you remove him.
No, I am making a suggestion.
Or nothing implied in the order is the fact that you've leveled such serious allegations against some people.
which cannot be sustained because no inquiry was held. That portion.
What is the solution here?
May I very respect, this is what I was saying, Madam. May I very respectfully submit the order itself is composed of these two components. One is that a public speech was made. The other is that there was an allegation made or there were some assertions made which were not inquired into, and that was also held against the petitioner. Now that portion cannot be held against the petitioner so far as the STC order is concerned because that was never inquired into. We are only then left, as far as this list is concerned, only left with the question whether the public speech that was made was
नहीं, देखिए, उसका बड़े implication होगा. I think let's live in the real world. The entire eyes of the nation are before us. There are 2-3 constitutional offices involved. One is at stake is the independence of the judiciary. If I'm sure you will also agree that no judge should be removed without cause. I'm sure you will say that.
yes, quite right. That's true.
That's one aspect. The other aspect is there's another constitutional body involved called the Supreme Judicial Council. Now, the Supreme Court should not interfere in the work of another constitutional body unless there is something so manifestly unconstitutional or unjust. What Mr. Hamid Khan Saab is saying is there was no inquiry held, and you are conceding it, and the Attorney General is also conceding it. Needless to say, if the statement made was false, he also concedes that the judge should have been removed. Now, the third issue is the Supreme Court itself. We are hearing this case. Now the question arises, what sort of order we can pass in such circumstances? And I think there's an interconnected, where is the Attorney General? Attorney General, where is he?
कलर मैं ऑफिस से चेक करवा लेता हूँ ऑफिस में.
बुला लिया अगर उनको.
खान साहब जरा ये ओपिनियन तो पढ़िए पेज 70 पे. Opinion of the Supreme Judicial Council.
Yes.
Page 70 पे.
70 पे. Yes. Conclusion, sir. This council is unanimously of the opinion, kindly see here, that in the matter of making his speech before the District Bar Association Rawalpindi on 21/7/2018, Mr. Justice Shaukat Aziz Siddiqui, Judge Islamabad High Court Islamabad, had displayed conduct unbecoming of a judge of a High Court and was thus guilty of misconduct, and he is therefore liable to be removed from the office under Article 2096 of the Constitution of the Islamic Republic of Pakistan. 2096, which says you inquire into the matter, which was never done. The other portion of this, your Lordship may find very relevant, is on page 49-50, where they decided to dispense with the inquiry.
इसमें सवाल इसमें ये पैदा होता है, ये सवाल है कि सपोज एलिगेशन दुरुस्त है, सपोज क्या ये जिस तरीके से एलिगेशन बयान की गई है, जिस तरीके से तकरीर, क्या ये एक जज के लिए मुनासिब था? ये तो ओपिनियन उनकी ये थी कि चूंकि कर नहीं सकते थे।
सर इसमें हुआ ये, there was only one hearing in camera done, nothing else was never
ये तो डिनाइल नहीं आपकी तरफ से कि तकरीर हुई थी
जी,
तकरीर हुई थी, ये डिनाइल तो नहीं है।
नहीं
वो ये
तकरीर का डिनाइल नहीं,
नहीं सर, तकरीर का डिनाइल नहीं,
बट देखिए अब देयर आर टू काइंड्स ऑफ स्पीचेस ना, आई मीन क्या इज अ जज नॉट अलाउड टू मेक अ स्पीच?
यस,
देखिए आई थिंक वी शुड नॉट फॉरगेट द फैक्ट्स. The fact is not making of the speech. If it's making of the speech, then probably half the superior judiciary will have to go home, because how many judges have made to the Bar Council's speeches? I mean, these are not too. So
that speech was made before a bar is
no. So it's not a question of mere making of a speech. It's the content of the speech. I think both go together. Now it depends what I say. If I say there should be, I go and tomorrow I make speeches, independence of the judiciary, this, that, the other, fine. I may even canvass a view which is different. But if I make allegation against someone, so I think you can't disconnect the two things. It's the nature of the allegation. Because I would say if otherwise, then we will have to read that Article 19 is not available to judges.
Yeah, that's what they.
I mean, okay, you may not agree with the judge's point of view, fine. I mean, but you remove him on that ground. The code of conduct doesn't say you can't make a speech. So on it, I don't think there's anything wrong per se in making a speech. Now, if you make some speech and you attack, launch a vicious attack or loaded attack or whatever you want to call it, that we cannot disconnect with it. We have to read it, see it together. I mean, I can't just say, oh, making of a speech. I mean, making of a speech is your right. Anybody's right.
And addressing,
I mean, it's not
District Bar Association.
By the way, you may be interested to know the United Kingdom, which is so conservative, judges give interviews. I mean, it's House of Lords. I mean, those restraints have far gone, and judges of the American Supreme Court, as judges of the Supreme Court, Justice Stephen Breyer and Justice Scalia's debates,
all make public.
Debates were pretty vicious on various law schools they were given. So let's connect it with the speech. Now, nobody's taking us to the next level. What do we do?
Yes, sir.
Can we personally ourselves inquire into the matter?
Sir, one thing which I just want to point out, there were a number of speeches made by Justice Kiani which was published.
I agree with you on that.
Very clearly.
I agree with you. It will be, I think it is connected with the content. भाई अगर आपने बिला वजह ऐसे इल्जाम लगा दिए to another I don't want to use the word institution, but it's important.
Yes.
Whatever department of the government आप कह लें, जो भी आप कहना चाहें. So naturally, it is not a nice matter. But if they are true, it changes, I think, the complexion of the matter.
Sir, page 70 अगर देख लीजिएगा, this is
solution मैं आपको ही नहीं बता रहा।
नहीं सर, solution तो ये है कि इस वक्त ये जो order है president का based upon the report of the Supreme Judicial Council need to be quashed.
देखें, Hamid Khan साहब, it's not so simple. Then we'll be faced with an allegation that the Supreme Court threw Khwaja Saab's clients under the bus and saved one of their own. Again, we have to be very fair to both sides because you made allegation targeting specific persons. So if we quash it, that means, effectively means that all that you said was true without an inquiry, one way or the other. Now, how can we, what do we do then?
So then the answer can be, I'm just making a humble submission, that let this order of the president be quashed, let the report be also quashed, and let the matter be remanded back to the Supreme Judicial Council to hold an inquiry.
Can this order be passed?
I believe so.
हमें असिस्ट करें।
लेकिन अगर सुप्रीम जुडिशियल काउंसिल बगैर इंक्वायरी के रिकमेंड कर देती है रिमूवल ऑफ
okay, are you saying it's inherent in fundamental rights and due process?
Yes.
Power of remand, can you remand the matter to the Supreme Judicial Council?
That can be consequential on the requestment of the order. It can be.
Khwaja साहब आप क्या कहते हैं इस
There are two ways.
नहीं, let's see. Khwaja साहब is a senior counsel. Let's see what his view is. Can we remand the matter to the Supreme Judicial Council or we can't?
My Lord, may I very humbly make a submission? It cannot be done because now there is nothing for the Supreme Judicial Council to inquire into because the petitioner's tenure has already expired. He is no longer, it goes back, he would no longer be a judge to be considered for purposes of removal, which is the function of the Supreme Judicial Council. So it does not fall within the functions of the Supreme Judicial Council at this stage. This is what my very humble submission.
So what is the solution? None?
This matter requires the determination or not?
Let's suppose we, for sake of argument, don't take it amiss, that we set aside the order. That means that that's implied in the order that all that he said, the judge, when he was a judge, was true. So you are condemned. Won't you be condemned?
It doesn't imply that, my Lord.
Why? Can you say everything I said was true? Therefore the order was set aside?
Yes. What he said, my Lord, so far as the allegations against specific persons are concerned, they came up for the first time before the Supreme Judicial Council.
No, he's been saying it from day one.
No, he hasn't. The specific allegations against persons, by naming them and naming the incidents also, they never figured in the speech, they never figured in the preliminary reply that was given to the Supreme Judicial Council. It was in the second reply, the additional reply that...
No, but one way or the other, why didn't the Supreme Judicial Council say something on it? They could have asked him, say it on oath.
Yes. What did the Supreme...
I don't know, I called you to cross-examine him. I don't know, whatever way.
I'll make a submission. What the Supreme Judicial Council did was, they asked for the then Chief Justice of Islamabad High Court for his reply on the allegations that were made by the petitioner vis-a-vis him. And he denied all those allegations.
But it's one denial,
I'm just making
one assertion.
Yeah. No, but more importantly, may I make a submission? I'd said that before also, and I'm trying to be as balanced.
See, you can't just say because he's Chief Justice, I believe him, and because he's a simple judge, I disbelieve him. That's no...
Now we come back to the speech itself. The sole ground on which the matter against the petitioner could have been sustained, this order can be sustained, is if this Honorable Court comes to the conclusion that that speech per se was sufficient for his removal because it came within the definition of misconduct.
Are you saying a judge cannot give a speech to a bar counsel?
No. What I'm making a submission. May I make a irrespective of whether it was true or not what the petitioner said, irrespective of that, because it maligned the judiciary as a whole.
How does it malign the judiciary?
Let's go through the speech itself, if your lordship would.
No,
and it maligned the Army Institute, the armed forces.
He is maligning you.
No. Not in the speech. In the speech, it is the armed forces, it is the judiciary. They are the judges of the Islamabad High Court.
Suppose the allegations are true, then what will happen?
Even then, the petitioner should not have gone public or made a speech before the bar.
Why?
He could have issued a contempt.
Why are you saying he he should not, unless you can specify some violation of some law, constitutional provision, or a constitute of the code of conduct of judges. You can't just say he should not have. You should refer to something because of this reason.
The code of conduct says something to
refer to that provision which says that judge cannot give a speech to the bar council or
it's
whatever.
Not a question of giving a speech. It is a question of giving a speech which maligns the judiciary.
Exactly, it's the contents of the speech.
Or which maligns any institution in the country. That is
Okay, now let us.
Only that has to be held.
एक second, Khan Sahab, एक second. Please refer to the code of conduct. Code of conduct मुझे निकालने. Which provision are you relying upon?
Well, may I very humbly submit, my lord, I am not taking sides in this case.
No, I know.
Because your lordship has called.
No, actually, देखिए, it's always beneficial to have a senior counsel like yourself.
I'm just
because we are just thinking aloud how to proceed.
Yes.
And we'll be next be calling upon the Attorney General as well. So, which possible misconduct provision can you bring him under?
There's one provision in the Code of Conduct, Hamza, which relates to public speech.
Article 2 up. Maybe you can read Article 2.
I'll read that and then I'll read Article 2 for your lordship, my lord, but I think there's another provision which talks about, this number 5. Yes, it's Article 5. May I very humbly submit? If it is to be stressed, it will fall under Article 5. Nothing beyond. I will come back to that also. Functioning as he does in full view of the public, a judge gets thereby all the publicity that is good for him. He should not seek more. In particular, he should not engage in any public controversy, least of all on a political question, notwithstanding that it involves a question of law.
It's not publicity he was seeking. He was, let's call him a whistleblower. Every whistleblower, you will say, is seeking publicity. What publicity he was seeking by this? You are assuming burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity that's good for him, he should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar councils. Yes, there will be the media there. So what?
So they are not engaged in any public controversy.
No, it says please to fall on a it's not the public, it's a political question. Where is politics here? There's no politics here.
It states in particular, he should not engage in any public controversy,
so if
least of all on political matters.
Let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No, there is.
So what should he do?
He should be writing to the Chief Justice.
Okay, he says failed.
He should be writing to the
failed.
And if there is somebody,
then what should he do? He should keep quiet about it.
If there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to approach him, to influence him in any of his decisions,
there's corruption. For instance, not this case. We are giving a simple thing.
What I'm saying,
and his colleague is taking a bribe. He writes to the Chief Justice, he informs the Chief Justice, doesn't do anything. He gets frustrated. Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine. You can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case.
But may I?
So which other article can you rely upon?
This is the only article, I suppose, my lord. There is an article which was invoked in the order itself.
Which one was that?
Kindly read second para of Article 2.
I'm going to read that. Right. Second para,
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes. This is my lord, I think.
But you are saying it comes under this too? What's your
What I'm
opinion?
saying is that these are the provisions which can be.
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because, my Lord, from
Qazi Sahab, we have an advantage in having you before us.
My Lord, I'm grateful for
ठीक है,
your thoughts.
the advantage is you are now well versed with SJC matters.
My Lord.
ठीक है, okay. The other SJC matters where you are proceeding again. One is finishing a complaint, right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where you proceeding against a judge? Why you proceed against a judge? With a view to remove him. So you have to give him some. I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
My Lord.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट। जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आप सब इन्होंने एक तकरीर में कर दी। दूसरा तरीका आप बता दें कि कैसे कर सकते
नहीं, उसका तरीका मैंने बताया ना, जो एलिगेशन लगा रहे हैं व्हाट इज आई एम अगेन लेट मी reiterate, I am not taking sides. I am saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there is nothing beyond that. Article 5 or and this para 2 of Article 2. And this is for this honorable court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So they were, and those specific allegations are not there in the speech. The order itself, when we read page 7, we read the conclusion. It is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is going back to the operation.
Is it the status which?
No, not at all. Not at all. It was just. I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something. Therefore, believe him and not believe the other part. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, if this is fine, this is all right, this does not amount to misconduct, then the order that this honorable court has to pass, the way to move forward is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be.
But if you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without any inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this honorable court wants to go into whatever the petitioner has, it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. as far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Don't you, let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, what would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How do you get to it?
What I'm saying is that not in this list, not in the case before.
How do we do it?
That your lordship takes suo moto action or takes some other action, but not any. It cannot be.
इनकी एक तजवीज आई है कि send it for review, back to remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I mean, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको सॉल्व करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it? ये पता.
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he's removed, recommends to the President, remove him. That's it. End of story.
The petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात तो नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person. It's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Hey, who was telling the truth? Oh, truth doesn't matter anymore. I keep emphasizing on truth. If he's the truth, I think all the maslas will go away.
No, just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Burning inside you.
Well, not within the framework of law, within the framework of Constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास,
नहीं ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद है, चलो हटा दो इसको. सारे हमारे सुप्रीम जुडिशल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें, कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं।
पिटीशन आती है, एक petition।
अगर देखिए एक बात है सब्स्टिट्यूटिंग योर ओपिनियन फॉर समवन एल्स, दैट्स अ डिफरेंट मैटर। The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even if someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge. We'll have to bring witnesses. We'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, like, each decision creates a precedent. So where should we go now from here?
They keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion.
Then the nation will hold us accountable.
Necessary, notwithstanding the allegations made. It was,
if you have finished, can we request the Attorney General? Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late, from what let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was so, whatever, it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, his findings mentioned twice, 5, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. ये इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, सवाल उड़ा।
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now we were hearing some other case.
Yes,
the same issue came up there also.
So my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned. 211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments is set.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, what I'm malafide in law is basically if the process is not followed. If what the law or the Constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction. So the court can proceed. The court can look into the movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but the question...
We can't say, okay, now please come and give oath and give it on statement.
This is
will cross-examine.
This is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter. But I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been
crossed that bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there is a judgment, a two-member bench's judgment in Afia Sheher Banu Zia's case, BLD 2023 Supreme Court 510. wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, if while he was on the bench, had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord. It has been filed.
What number hai?
My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course,
if the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
now, so in this
If in the meantime he retired, for instance,
so in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the judge was, the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case. Also,
Yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Acha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
Is remand permissible?
if my lord,
If you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
if Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that
No, but
distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this.
If we accept this petition,
Yeah.
what will happen? So we will simply
Things can happen. Two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who had retired.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out. That iska implication generally kya hoga? You may want to do something, but it may have wide-ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Wouldn't you want to, as they say, get to the truth of the matter?
My lord, so I just got called on short notice, but
I know that's not fair.
What I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been
Serious
denied.
allegations, not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence. Is not the forum for doing it.
Is there a solution?
The solution, my lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned and this matter is remanded to the order of the Supreme Judicial Council is set aside and the matter is remanded to Supreme Judicial Council, then as far as the inquiry of these allegations is concerned, that perhaps is the only forum.
And then question arises that the man has retired. What will happen?
So for that purpose, you have to overturn Afia Shehrbanu Zia. For those purposes, you have to first this court has to overturn Afia Sher Banu Zia in order to cross that barrier and then go to the...
This case is slightly different. He was not retired at that time.
That's right. He was still before the court. Now, the question would still be that if the petition is allowed, what could be the consequence? Now, if... limited consequences.
जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he is corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports whatever, remove him. He is removed. Now, naturally, when he'll file the petition, he's already stand retired.
That's right.
So I don't think the date would there be. He has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad. Whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has...
इसका solution क्या है फिर?
So इसका solution, sir, to my mind,
आप कह रहे हैं कि इसको क्लब करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously, there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And his
nobody could have thought this would connect there.
About 3 years.
So if he had 3 years to his service left.
No, Dekhi, like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously,
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by.
But that delay we are accountable for in this particular case, because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not.
So, कितनी hearings हो गई थी इसमें?
बेशुमार सर. Many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं, हमने कितनी दफा सुना इस केस को?
मैं आपको ऑर्डर शीट दिखाऊं.
ये दूसरी दफा है, हम मेरे साथी याद दिला रहे.
But we are responsible for our senior.
अक्टूबर 2018 में ये पिटीशन फाइल.
2000
ना नहीं, वो क्योंकि वो पार्टी नहीं बनाया था ना, उसमें भी टाइम लगा. वो आपका कसूर था खान साहब, थोड़ा हमारा कसूर था, मगर वो आपका कसूर था, मान लीजिए. क्योंकि आपने एलिगेशंस लगाई थी against people who were not before us, so we had to give them a notice. So that goes in your. We don't accept responsibility for that.
But the question that even shows that this was a case.
Wasim Sajjad Sahab, can we benefit by your acumen? Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through studying it properly, because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. once the matter is before your lordship also has the power to do complete justice under Article 187. So there is no impediment.
आपकी अपील कब लगी है?
My Lord, filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office fixes it.
The point that you want to say at this juncture? Anyone, any of the council or?
This is one of the exceptional cases. Earlier cases, like Justice Shaukat Ali's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases, Ikhlaq Hussein's case, where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore, my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases,
earlier
where
cases
inquiries were held?
One is Justice Shaukat Ali's case is PLD 1971 Supreme Court.
1971 Supreme Court,
page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
recommended the judge's removal. As in the next case is, this is Justice Shaukat Ali.
Earlier case was Justice Ikhlaq Hussein's case, PLD 1960 Supreme Court. Yeah, page 26 perhaps.
जी
अच्छा उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे चलें खैर अगला वाला बताते हैं कोई और भी केस है
ये दो केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। तो सर एक और बात 1956 का मैंने कॉन्स्टिट्यूशन एग्जाम देखा है उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
Under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution.
किसमें नहीं था?
ये इसमें नहीं था अखलाक हुसैन वाले केस में स्टेट वर्सेस अखलाक हुसैन
नहीं वो कौन सा आइन था जिसके आप जिक्र कर रहे हैं
56 का
उसमें नहीं था
उसमें ये नहीं था कि इंक्वायरी जरूरी है
उस आइन की कौन सी शेख थी
उस आइन की शेख थी आर्टिकल 169 अच्छा
169 अच्छा इसमें नहीं था
उसमें अब आप आई रीड दैट आउट
नो इंक्वायरी रिक्वायर्ड हाँ जी
A judge of a high court shall not be removed from his office except by an order of the president made on the grounds of misbehavior or infirmity of mind or body. If the Supreme Court उसमें Supreme Judicial Council नहीं Supreme Court ये function करते If the Supreme Court on reference being made to it by the president reports that the judge ought to be removed on any of those grounds. ये Article 169 था उसमें और इसके बावजूद भी डिटेल इंक्वायरी की गई थी उसमें और डिटेल इंक्वायरी
अखलाक हुसैन का केस था तो 56 कॉन्स्टिट्यूशन वाज अंडर कंसिडरेशन और द 60 कॉन्स्टिट्यूशन
अंडर द 1956 कॉन्स्टिट्यूशन
अच्छा मगर उसके बावजूद भी इंक्वायरी हुई
थी सो मेरी गुजारिश ये है कि दिस इज द फर्स्ट केस ऑफ दिस नेचर वेयर ए जज इज रिमूव्ड विदाउट इंक्वायरी It will have a repercussion for the future because judges of the Supreme Court has no other security available to him except that a Supreme Judicial Council makes inquiry into the allegations. If that is taken away from him, then he is left on the mercy of the person who alleges against him, whether he is president or whether he is any other person making a complaint. So therefore, my submission is that a detailed judgment is required to give why inquiry is so necessary in cases where the allegations against the judge of the superior courts, for which there cannot be any recommendation for removal without holding a proper inquiry into it and giving a statement of allegations. Even in the case of Ikhlaq Hussain, there were 3 allegations, specific allegations made. Similarly, in case of Sheikh Shaukat Ali in 1971, specific allegations were made against him, on which inquiry was held. In here, no statement of allegations was ever given to the petitioner, and naturally,
और भी केस था ना वो खान साहब वाला
जी,
एक और भी केस था ना, वो रिपोर्टेड है या नहीं है?
ये दोनों केसेस तो
फजले गनी खान साहब का कोई उसमें केस चला था या नहीं चला? चला नहीं था।
उनका
नहीं चला था? नहीं चला। नो सर।
खान साहब एक बात बताएं आप, इसके अंदर तो एलिगेशन डिफरेंट है शौकत अली साहब वाले में और इखलाक हुसैन साहब वाले में। यहाँ पर जो इंफॉर्मेशन की बात है, सब सेक्शन 5 ऑफ आर्टिकल 209, वो इंफॉर्मेशन की बेसिस पे, लेकिन यहाँ तो सुप्रीम कोर्ट ने खुद कॉग्निजेंस लिया है, तो यहाँ तो कॉग्निजेंस लिया है इसने। वहां पे इंफॉर्मेशन किसी पब्लिक पर्सन ने, किसी ने कोई इंफॉर्मेशन तो नहीं दी है। तो इंक्वायरी उस सूरत में करी जाए जब कॉग्निजेंस लिया है कोर्ट ने, खुद रजिस्ट्रार ने दूसरा लेटर भेजा है, बिल्कुल उसकी बेसिस पे। तो ये चीज जो है यहाँ पे जरूरी है, इंक्वायरी बहुत जरूरी, जब कॉग्निजेंस सुप्रीम कोर्ट खुद ले रहा है,
और भी ज्यादा जरूरी हो गई है। जनाब ने बिल्कुल दुरुस्त फरमाया, और भी ज्यादा जरूरी हो गई है। हुआ ये था कि 1956 कॉन्स्टिट्यूशन में
ये केसेस में कुछ एक आध मेरे हिसाब से कुछ करप्शन का भी केस है इसमें।
जी डिस्टिंग्विश्ड, बट आई एम जस्ट सेइंग द प्रेसिडेंट अवेलेबल विद अस। गुजारिश ये है कि इसमें हिस्ट्री की ये है कि ना 56 कॉन्स्टिट्यूशन में विदाउट प्रेसिडेंशियल रेफरेंस किसी जज को रिमूव किया जा सकता था, ना 62 के कॉन्स्टिट्यूशन में ये हो सकता था, 73 कॉन्स्टिट्यूशन में भी नहीं हो सकता। फॉर द फर्स्ट टाइम 17th अमेंडमेंट में ये लाए गए थे, द काउंसिल ऑन इट्स ओन, द काउंसिल में ऑन इट्स ओन मोशन। ये पहली दफा 2005 में इंट्रोड्यूस किया कॉन्स्टिट्यूशन में कि इवन सुप्रीम जुडिशल काउंसिल विल हैव द पावर ऑन इट्स ओन, ऑन द बेसिस ऑफ कंप्लेंट अवेलेबल, कैन प्रोसीड against a judge of the. This is the case here. It is not a case of presidential reference. It is a case with Supreme Judicial Council.
कैसे शुरू हुआ ये जरा में दिखाइए।
लेटर रजिस्ट्रार सर
दोबारा ये बताएं कैसे।
क्या सुप्रीम जुडिशल काउंसिल ने क्या अपने तौर पे ये उठाया या
वो किधर
या रजिस्ट्रार ने एक नोट लिखा? रजिस्ट्रार ने किस कैपेसिटी में लिखा?
ये अपने तौर पे ना कंप्लेंट है,
ये वो दिखाएं
रजिस्ट्रार ने किस कैपेसिटी में दी, ये भी देखना है।
दिखाएं क्या चीज है
उसको।
39 पेज के ऊपर है ये, 39 पेज पे पैरा 3,
23/7/2018 को रजिस्ट्रार ने
ये पेज नंबर 39 ऑफ द पेपर बुक।
जी सर, ये है सर। यहाँ पर
अपॉन पेरियल ऑफ द नोट पुट अप बाय द सेक्रेटरी ऑफ द काउंसिल।
ये नोट किधर है, किस पेज पे?
नोट नीचे है सब दिया हो, पैरा 3 में
है। आपके कॉपी लगाई आपने? एक्चुअल
लगी हुई है?
जी कॉपी लगाई। इन्होंने खुद भी जो जवाब दिया है रजिस्ट्रार ने,
वो दिखा देना एक्चुअल नोट कहाँ है।
जी सर, ये 21/7/2018 ऑनरेबल मिस्टर जज सिद्दीकी एड्रेस।
पेज कहाँ है? पेज कौन?
ये पेज 39 पे सर।
नहीं, ये तो उसका रिप्रोडक्शन है ना।
रिप्रोडक्शन है,
मुझ में एक्चुअल नोट दिखाइए मुझे।
एक्चुअल नोट हमारे पास तो नहीं है, ये हमें तो
ये डॉक्यूमेंट फाइल किए, इसमें क्या है सारे ये
अब उन्होंने जो जवाब दिया।
पेज पे एक लेटर है अरबाब मोहम्मद आरिफ साहब का
जी,
कंप्लेंट अगेंस्ट मिस्टर जस्टिस शौकत अजीज सिद्दीकी, जज इस्लामाबाद हाई कोर्ट, 31 जुलाई 2018 का है।
जी हाँ
जी, आई एम डायरेक्टेड टू सर्व अपॉन यू द एनक्लोज्ड। ये तो बाद में है ना।
कंप्लेंट जो इन्होंने रिसीव की है वो 23/7 की है, जो रजिस्ट्रार ने कंप्लेंट
मेंशन किया, उसको रिप्रोड्यूस किया हुआ है पेज नंबर 39 में पैरा 3 में रिप्रोड्यूस किया हुआ है।
जी हाँ, बिल्कुल सही, एग्जैक्टली वो रिप्रोड्यूस किया। The note put up by the registrar and the transcript of the speech. Note जो है,
ये नोट
Note on top of page 39, on 21/7/2008, Honorable Mr. Justice Siddiqui addressed District Bar Association, Rawalpindi. During this speech, he said, page 39 sir,
ये पैरा 238 से शुरू हो रहा है.
page 39 के ऊपर जो फर्स्ट पैरा, आप देखिए.
नहीं, वो तो एलिगेशन है ना
जी, एलिगेशन है.
अच्छा, नीचे पैराग्राफ 2 से पढ़िए.
सर ये पैरा 2 on page 38.
जी.
On 23/7/2018, the Secretary of this Council, Registrar Supreme Court of Pakistan, submitted the following note before the Chairman of the Council, Chief Justice of Pakistan. ये वो फिर नोट 23/7 को ये लिखा गया. On 21/7/2018, Honorable Mr. Justice Siddiqui.
No, he was acting pursuant to a direction of the Supreme Judicial Council, or my Lord has asked, Justice Jamal has asked that he did it himself. Ek na, you do it. One is he does it, comes before the Supreme Judicial Council.
So it doesn't say so much, but it appears that there was some kind of a.
We will go by the Constitution. Constitution says the Council on its own.
On its own.
Secretary is not the Council. He may be complainant.
It may be.
He's part of the. He's part of the Supreme Judicial Council.
Maybe the Council had directed him to do it. I don't know.
The thing is, on record कोई चीज नहीं है. लेकिन ये
मतलब उसने अपनी पर्सनल कैपेसिटी में दिया.
आप ये हियरिंग जो, अच्छा एक चीज बताइए,
आप जनाब पढ़ लीजिएगा.
कितनी दफा सुप्रीम जुडिशल काउंसिल में ये केस लगा आपका? आप कितनी दफा सुप्रीम जुडिशल काउंसिल ने आप लोगों को तलब किया?
एक दफा. Only on one occasion.
What happened on that occasion?
On that occasion, we said that please, in the first place.
No, you asked something. Why were you called?
We were called to explain as a preliminary hearing before inquiry and preliminary hearing hoti under the.
Were you was the petitioner alone or was he assisted?
I was with him.
क्या हुआ था? बताएं क्या हुआ था उस दिन?
उसमें यही क्वेश्चन हुआ कि ये क्या स्पीच की है आपने? देखिए, we made a speech which we.
नहीं, वो ठीक है, बस. So it was a casual, formal meeting. What वो charge frame हुआ आपके खिलाफ क्या हुआ?
कोई charge frame नहीं है, कोई charge frame नहीं है. बल्कि इससे पहले.
No, we may need to see the record of the Supreme Judicial Council.
ये जरूर देख लीजिएगा. कोई कहाँ यहाँ भी कहीं रिपोर्ट में भी नहीं कहा गया कि कोई charge frame हुआ है. रिपोर्ट में देख लीजिएगा ना, कहीं पर ये नहीं कहा गया कि मेरे खिलाफ कोई चार्ज फ्रेम हुआ, स्टेटमेंट ऑफ एलिगेशन दी गई जिसका मैंने जवाब देना था. नथिंग ऑफ दैट सर.
आपको कोई शोकॉज नोटिस नहीं हुआ?
शोकॉज नोटिस दिया.
वो किधर है?
वो शोकॉज नोटिस
74 पे, 74 ऑफ द पिटीशन.
ये जनाब पेज
42 पर रिप्रोड्यूस भी हुआ है.
पेज 74 पर है.
इसका ये तो वेरेस अच्छा नाउ यू ये पेज 75 पे आ जाइए ना. ये ना
ये है जी पेज 75 पर. नाउ योर लॉर्डशिप आर हियर बाय कॉल्ड अपॉन टू एक्सप्लेन योर कंडक्ट विद रिगार्ड टू द फॉलोइंग एलिगेशंस व्हिच prima facie constitute misconduct on your part within the meaning of paragraph B of clause 5 and clause 6 of article 209 of the Constitution. You were, while addressing the District Bar Association Rawalpindi on 21/7/2018, have leveled the following serious allegations pertaining to superior judiciary and a state institution.
देखिए, इधर the question of seeking publicity नहीं allegation है.
ये नहीं है.
ये तो allegation वही है ना, substance पे जा रहे हैं state में. It's not. अच्छा.
Making a speech and on the content of this speech actually.
पढ़ें.
That ISI is fully involved in manipulation of judicial proceedings, including marking of cases to honorable benches. 2. That ISI personnel approached Chief Justice Islamabad High Court and asked him not to let Mr. Nawaz Sharif and his daughter come out of prison before general elections 2018 and not to include your lordship in the bench. And that Chief Justice Islamabad High Court responded that the bench will be constituted as per their desire. That your lordship claimed to even have knowledge of the person who conveys messages to the Supreme Court. Court, that daily proceedings of Accountability Court were being reported somewhere, and that your lordship also knows the reason why the administrative control of Islamabad High Court as per statute was removed, so that no judge could look into the proceedings, that your lordship was asked to give assurance that your lordship would give decision as per their request, and then references pending against your lordship would be closed. That if your lordship decided cases according to their desire, your lordship would be made Chief Justice Islamabad High Court by September 2018. Upon presentation of the transcript of your speech, Honorable Chief Justice of Pakistan had been pleased to observe that the allegations leveled in the speech had cast aspersion and maligned the superior judiciary of the country and berated its independence. It also implies some other national institutions. And the Honorable Chief Justice of Islamabad High Court was asked to comment upon the veracity of the allegations leveled against him. He was also asked to obtain from your lordship the material evidence available, if any, to be immediately transmitted to the office of the Chief Justice of Pakistan for consideration and appropriate action if necessary. In response, Honorable Chief Justice of Islamabad High Court offered his comments by letter dated 29/7/2018, wherein his lordship responded that while a letter dated 24/7/2018 received from your lordship regarding allegations leveled against Honorable Chief Justice of Islamabad, his lordship has categorically denied all the allegations. The above act on your part amounts to misconduct as envisaged in the provisions inter alia of Article 2, 3, 5 and 9 of the Code of Conduct prescribed by the Supreme Judicial Council. One fact I want to bring to the notice, sir. At the time when these proceedings were initiated, proceedings were going on against Justice Anwar Qazi, Chief Justice of Islamabad High Court, before the Supreme Judicial Council for quite some time. I remember in another case when he sat on the Supreme Judicial Council and I objected. That was a case where I was counsel for Justice Farooq Irfan. I objected to his sitting on the Supreme Judicial Council on the ground that under Clause 3 of Article 209, a judge against whom proceedings in the Supreme Judicial Council were being
was it the same matter or some other matter?
That was a question. They declined that.
I don't understand your contention. Are you saying, suppose...
I'm disclosing, I'm stating facts.
No, 1 second. Fact, you may be stating, but you are making a legal implication out of the stated facts. Now, for instance, suppose the Supreme Judicial Council is legitimately convened to inquire about a judge. It may be used as a tactical ploy to file complaints against all the members of the Supreme Judicial Council and then say, oh, none of you can hear the matter. So merely that in itself is nothing relevant unless there's a direct nexus. Otherwise, तो इधर बड़ा खूबसूरत होगा. इनके भी खिलाफ कर दो वो फेल ही हो गया Supreme Judicial Council.
मैंने ज़िमनन बताई कि उस वक्त ये ऑब्जेक्शन इसलिए लिया गया था कि Justice Anwar Qazi was under inquiry in another case against him.
देखिए खान साहब,
आप रिकॉर्ड मंगा लें.
खान साहब सॉरी, या तो आप इसको कोई दलाइल देना कानूनी आईनी, ये मुझे बात समझ नहीं आ रही है भाई. हमें नहीं पता कल कोई 50 कंप्लेंट फाइल कर दे सब जजेस के खिलाफ तो सुप्रीम इदारा ही खत्म हो जाएगा.
नहीं, वो इंक्वायरी वहां होती है जहां सुप्रीम जुडिशियल काउंसिल सेज दैट देयर इज अ प्राइमा फेसी केस for proceeding against him. There was a case which was going on, inquiry was going on.
How would that matter to him, to the petitioner?
How it
maybe he gets removed, both get exonerated.
मेरी बात मुकम्मल सुन लीजिएगा फिर उसके बाद.
हाँ बताइए.
हुआ क्या? ये जो फैक्ट्स यहाँ दिए गए हैं कि उनको खत लिखा गया था कि बताएं ये एलिगेशंस हैं, उन्होंने डिनाई किया. What happened? मुझे 11 अक्टूबर को रिमूव किया गया ऑन द रिपोर्ट ऑफ द सुप्रीम जुडिशियल काउंसिल. उसी दिन या उससे अगले दिन उनको एक्सोनरेट कर दिया गया फ्रॉम द चार्जेस ही वाज फेसिंग बिफोर.
सीरियस एलिगेशन लगा रहे हैं.
दैट द वेरी नेक्स्ट डे ये फैक्ट्स जनाब आप
आई एम सेइंग फॉर द सेक ऑफ आर्गुमेंट्स, इफ दीज फैक्ट्स आर करेक्ट, व्हाट डज इट मीन
It means, sir, that वो चूंकि गवाह बन गए हमारे खिलाफ, तो उसको उसकी जो एलिगेशन से उसे एग्जम्प्ट कर दिया गया।
नहीं, क्या वही कंप्लेनेंट दोनों केस में था या तो कुछ ऐसा नेक्सस जोड़िए ना।
ये बातें और है, मैं सिर्फ जनाब को बता रहा हूँ कि सुप्रीम जुडिशल काउंसिल ने किया क्या। जब उन्होंने मेरी एलिगेशन को डिनाई किया तो उनको छोड़ दिया।
जहां तक आपकी बात सब देखिए, हम सुप्रीम जुडिशल काउंसिल पे ऐसे उंगलियां नहीं उठाएंगे। जहां तक आपने बात की ना इंक्वायरी की, वो तो हमें समझ आ गई ना, आपने एक आईनी बात कर दी, वो समझ आ गई। अब ये हो सकता है, नहीं हो सकता, अभी हमें इस मफरूजों में क्यों जाएंगे। नहीं, लेट्स स्टे आइन पे बात करें, क्योंकि अब आप 184(3) में आ रहे हैं। देखिए, इसमें 184 का दरवाजा खुलता है, इसमें पब्लिक इंटरेस्ट का एलिमेंट आ जाता है। हर जज की सिक्योरिटी ऑफ टेन्योर एंड इज रिमूवल आई थिंक इज अ मैटर ऑफ पब्लिक इंपॉर्टेंस, इसलिए उसका दरवाजा खुल जाता है। आ गई बात इन्फोर्समेंट ऑफ फंडामेंटल राइट्स, आपने बात कर दी ड्यू प्रोसेस एंड फेयर ट्रायल, बिल्कुल ये भी समझ आ गई। मगर अब ये जो बाकी चीजें, ये मैं तो ये इसमें कुछ समझ नहीं आ रही बात, इसलिए कि जो हो सकता है सही भी हो तो सो व्हाट।
ये पोर्शन मैंने पढ़ के, आपने कहा तो मैंने पोर्शन पढ़ा।
अच्छा, इसको छोड़े, कोई और बात करें।
चलिए, तो मैं
नहीं, कोई और बात करें तो बताएं।
मेरी तो गुजारिश सिंपल ये है कि दिस इज अ केस वेयर ए जज हैज बीन रिमूव्ड विदाउट फॉलोइंग द ड्यू प्रोसेस।
We got the point. And we are just saying how to go forward. That's all.
This order has to go. This report has to go. Has to be quashed. So that in the future,
but what about the public interest in the matter? They need to know. So, or they are not entitled to know.
उसके लिए मैंने ऑलरेडी सबमिशन की है कि ये ऑर्डर सेटिसाइड होके इसको जनाब रिमांड कर सकते हैं सुप्रीम जुडिशियल काउंसिल एंड इंक्वायरी इनटू द मैटर। दैट इज द आंसर टू माय माइंड। इफ यू लॉर्डशिप थिंक्स,
अगर आप नहीं, ठीक है, इफ यू कंक्लूडेड, वी डोंट कट यू शॉर्ट, कैन वी मूव ऑन टू सलाउद? आई जस्ट सॉ दैट ही इज इन कराची।
जी ठीक है सर, मेरी सबमिशन ये है कि रिमूवल विदाउट इंक्वायरी इज अनकॉन्स्टिट्यूशनल एंड ऑट टू बी स्क्वेश्ड।
आमिर साहब, आप इस एस्पेक्ट को तो डिनाई नहीं करेंगे कि जस्टिस सिद्दीकी साहब को एम्पल अपॉर्चुनिटी ऑफ हियरिंग दी गई थी, क्योंकि प्रोसीडिंग्स 2 महीने से ज्यादा चली हैं और कम से कम 2 से 3 रिप्लाईज इन्होंने जमा कराई हैं। मैं आपसे पूछ रहा हूँ, हामिद साहब आपसे पूछ रहा हूँ।
जी सर, सॉरी,
मैं ये कह रहा था कि आप इस एस्पेक्ट को तो डिनाई नहीं करेंगे कि जस्टिस सिद्दीकी साहब को एम्पल अपॉर्चुनिटी ऑफ हियरिंग दी गई है, 2 महीने से ज्यादा प्रोसीडिंग्स चली हैं और इन्होंने कम से कम 3 से 4 रिप्लाईज अपनी जमा कराई हैं। लिहाजा ये एस्पेक्ट कहना कि जी इनको अपॉर्चुनिटी ऑफ हियरिंग मिली ही नहीं या इनको टाइम नहीं दिया गया, तो ये तो किसी अब तक के दुरुस्त मालूम नहीं होता रिकॉर्ड से। देखिए, अब प्रोसीडिंग्स शुरू हुई हैं 23/8 को और कंक्लूड हुई है 1 अक्टूबर को, यानी कि तकरीबन 2 महीने से ज्यादा चली है प्रोसीडिंग्स। और सुन तो लीजिए, और कम से कम 2 से 3 दफा इनकी रिप्लाईज आई हैं और उनकी रिप्लाईज जितनी भी हैं वो सुप्रीम जुडिशियल काउंसिल ने कंसीडर करी हैं और सारी रिप्रोड्यूस की हैं अपने ऑर्डर के अंदर, और उसके बाद फिर इनके खिलाफ ये फैसला दिया गया है कि जनाब ये मिसकंडक्ट के मुर्तकिब थे। इसके बारे में आपका क्या कहना?
जी, मैं ये कहता हूँ, उन्होंने एक शोकॉज नोटिस दिया 31/7/2018, उसके जवाब में एक प्रिलिमिनरी मैंने सबमिशन की, क्योंकि 14 दिन दिए गए थे। मैंने कहा मैंने फैक्ट सारे डॉक्यूमेंट्स कलेक्ट करने हैं और मैं एडिट रिप्लाई दूंगा। फिर मैंने एडिट रिप्लाई दी, ये 2 रिप्लाईज मैंने दी। एक एप्लीकेशन मैंने और दी उस पे, जो रिकॉर्ड पर है पेज 223-24 पे। उसमें मैंने कहा कि इन द फर्स्ट प्लेस addressing a district bar association is not a misconduct within the meaning of Article 209. But if this honorable council thinks that this is a case in which I should be proceeded against, please in that case give a public hearing to us. Give it as an open court. मैंने ये एप्लीकेशन दी, जिसको कभी उसके बाद एक इन कैमरा प्रोसीडिंग्स हुई, उसमें भी मैंने ये बात रिपीट की कि अगर जनाब मजीद प्रोसीड करना चाहें, उनको तो प्रिलिमिनरी इंक्वायरी थी, वो कोई फाइनल इंक्वायरी जो है सिटिंग नहीं थी, तो मुझे आप ओपन हियरिंग दीजिएगा। ये पेज 313 के ऊपर ये मौजूद है मेरी दरखास्त, पेज 313 पर, पेज 313, ये वॉल्यूम 2 होगा जी इसका, इस केस का पेपर बुक 2। इसकी तारीख है 29/9/2018।
पेज क्या बताया था आपने?
ये आएगा the applicant
पेज आप दोबारा
313 sir
313
application for open hearing guaranteed under the Constitution of the Islamic Republic of Pakistan।
ये इसकी आपकी इस्तदा कौन से पेज पे? इस पे फैसला क्या हुआ?
It is therefore prayed।
इस पे क्या फैसला हुआ?
जी
डिसाइड क्या हुआ? डिसीजन
नहीं, उसमें नहीं हुई। I was never given any hearing। इसके बाद the one hearing was in camera।
इसमें इशू तो ये है कि जहाँ तक तकरीर की बात है, आप तकरीर डिनाई नहीं कर रहे हैं। मालूम सिर्फ ये करना है कि ये मिसकॉन्डक्ट में आता है या नहीं, नंबर 1। इसका दूसरा एस्पेक्ट जो है, जो कि बार बार मैं इंसिस्ट कर रहा हूँ, वो ज्यादा इम्पोर्टेंट है कि वो जो एलिगेशन थी उसको मालूम करना चाहिए था दुरुस्त थी या नहीं थी। तो क्या सुप्रीम जुडिशल काउंसिल वो तहकीकात कर सकती है? सपोज अगर आज हम रिमांड भी करते हैं तो क्या वो तहकीकात वहाँ हो सकती है या इसको कहीं और होना है?
हाँ, बिल्कुल इसमें इंक्वायरी होनी चाहिए थी, बल्कि पहला
कौन करेगा इंक्वायरी?
सुप्रीम जुडिशल काउंसिल को करनी थी ना।
नहीं, वो दूसरी एलिगेशन की जो इन्होंने एलिगेशन लगाई उसके बारे में क्या कहते हैं?
तो एलिगेशन
ये जो कह रहे हैं, जो कोर्ट्स पे जो बाकी रिस्पोंडेंट्स पे जो एलिगेशन लगी है, क्या सुप्रीम जुडिशल काउंसिल उस हद तक तहकीकात कर सकती है?
बिल्कुल कर सकती थी। और बल्कि मैंने ओपन हेयरिंग के लिए कहा था कि आप हमें ओपन हेयरिंग दें।
देखिए, शायद मैं क्लियर नहीं कर रहा हूँ। आप पे ये एलिगेशन तो नहीं है कि आप सही कह रहे हैं या गलत कह रहे हैं। आप पे एलिगेशन ये कि आपने जुडिशरी को मलाइन किया, जो कि मिसकॉन्डक्ट में आता है।
ठीक,
वो तो आप मान रहे हैं कि तकरीर की सिर्फ ये देखना है कि आपकी तकरीर ज़मरे में आती है या नहीं, लेकिन जो एलिगेशन है उसकी तरफ तो किसी ने तवज्जो नहीं दी कि वो एलिगेशन किस हद तक दुरुस्त है, किस हद तक गलत है।
उसकी
गलत है तो ही शुड फेस द कॉन्सिक्वेंसेज, और अगर दुरुस्त है तो वो रिस्पॉन्सिबल। लेकिन सवाल ये कि कौन करेगा?
लेकिन उन्होंने इंक्वायरी करनी थी ना इसमें। पहले तो मुझे स्टेटमेंट ऑफ एलिगेशंस देना था कि ये एलिगेशंस हैं इनका, इसको आप
कोई स्टेटमेंट ऑफ एलिगेशन
कुछ नहीं किया गया। सो गुजारिश मेरी ये,
सुप्रीम जुडिशल काउंसिल वेरी पावरफुल बॉडी। आप जरा 210 में पढ़ लें आइन का।
ये बिल्कुल सही है कि
जरा देखिए, इसकी जरा मैंने अभी इसके जरा अल्फाज का चुनाव जरा देखिए।
पावर ऑफ काउंसिल टू एनफोर्स अटेंडेंस ऑफ पर्संस। यस,
नहीं टेक्स्ट पढ़िए ना।
फॉर द पर्पस ऑफ इंक्वायरिंग इनटू एनी मैटर
not pertaining to, it doesn't connect with the conduct of the judge. अब यहाँ widened up the scope. जरा पढ़े आगे।
सर वो इससे कनेक्टेड
नहीं, जरा चले पढ़ते हैं आगे।
Council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction or order shall be enforceable as if it had been issued by the Supreme Court. The provisions of Article 204 shall apply to the content powers. So
it's a very powerful body. It can call anybody.
That is what, in the context of inquiry, naturally, it has to be.
It's not hearing a case. It's inquiry. So वो आपने जो इंक्वायरी कमीशन की बात की, तो ये खुद ही इंक्वायरी कमीशन है in a way.
बिल्कुल
more powerful than इंक्वायरी कंटेम्प्ट के पास भी इनके पास है।
बिल्कुल सही है। मैं इसीलिए कह रहा हूँ, मैं submitted, the answer is
Khan Sahab, let me put my anxiety to you. Every Supreme Judicial Council is not the Supreme Court. It's a separate constitutional body. Agreed? Every constitutional body should have maximum autonomy to decide matters. Agreed? Thirdly, we don't want to encroach or say or do anything. It just so happens that I'm a member of the Supreme Judicial Council as well, but we create precedent as well, that it undermines the Supreme Judicial Council. Supreme Court is not a watchdog over. However, like every other constitutional body, when a constitutional provision or a fundamental right is being violated by anybody or not being considered, let's both ways, then the Supreme Court is the only court which has the power, or the High Court, not in this case, to direct that this be done.
Yes.
So we have to be very careful how we proceed in this matter, because it will, like you are citing Justice Clark's case after 50 years, this will become precedent and it will be cited before us maybe earlier than 50 years. So we have to be very careful as to not disturb the perfect balance that the Constitution makers have provided in the Constitution.
There is an intervening judgment 2018 की, उसमें ये सारे एस्पेक्ट्स बहुत अच्छे डिस्कस हुए हैं और उसमें ये आया, उसकी हैसियत क्या है ये भी डिस्कस हुई है. मेरी गुजारिश है उस जजमेंट को जरा PLD 2018 सुप्रीम कोर्ट 538. I was counsel that case. Again, Shaukat Siddiqui's case.
This is Iftikhar Chaudhry's case.
This is PLD 2018.
वो अच्छा एक और जो आपका मैटर, नहीं ये नहीं करा, ये तो आप ही का केस है ना.
जी वही. इसमें ये एस्पेक्ट, प्रोसीजरल एस्पेक्ट्स बड़े डिटेल में डिस्कस हुए हैं.
Which part you want to read from?
जी अब मैं आपको वो जो है ना बता दूं कि वो मेरे नोट्स दूसरे वाले नोट्स में
पेज 5559 पे आ जाए.
538 से जनाब
पेज 5559 पे पैराग्राफ 51.
My Lord, my lords, am I needed for these proceedings, or can I be excused for now?
Is there something urgent?
Yes, I have. There is a matter which I have to argue, not before.
Okay, fine. ठीक है.
But
कोई बात हुई उनको बता देंगे. But you've noted the points, नहीं?
I have.
ठीक.
Sir, this judgment is very thorough judgment discussing various aspects of Article 209. पहला जो point out करूंगा वो पेज 555 है, पैरा 46.
जी.
Historically, page 555,
historically,
46. Historically, the fundamental rights of the people require protection from the excess of the executive and the vested interest, both commercial and political. In order to safeguard the fundamental rights of the people guaranteed under the Constitution, the independence of judiciary obviously must be insulated from the onslaught of the executive and such vested interests who are past masters at institutional capture. Thus, the security of tenure of judges, more so those of the superior courts, is imperative, and therefore adequate safeguards in this behalf are provided, including by enacting what appears to be a rather cumbersome and strict process of their removal. This cardinal principle is reflected in the constitutional dispensation of all the democratic countries, people by citizens and not subjects. The exception in this behalf are almost always found in...
Fine, you don't need to say this, it's obvious. जी.
नहीं सर, एक ये बात जो एक बहुत इम्पोर्टेंट एस्पेक्ट है वो जनाब देखिए पेज 559, ये जरा पैरा 51, ये जरा जरूर देखिए. पेज 559 पैरा 559 पेज पैरा 51. The relevant provisions of the Constitution, more particularly Articles 209, 210 and 211, when examined in the light of the judgment handed down by a larger bench of this court in the case reported as Chief Justice of Pakistan Iftikhar Ahmed Chaudhry, and the previous pronouncements on the subject noted and quoted with approval in the aforesaid judgment, the relevant portions whereof have been reproduced in extenso herein above, should reveal that, firstly, the SJC is a unique forum created by the Constitution. Secondly, the SJC is not a court, though it may exhibit some of its trappings, including the power to punish for contempt. So it is not a court. ये 2010 की जजमेंट भी। Thirdly, the proceedings before SJC are essentially a fact-finding inquiry, sir. This is what I am submitting here. This is the function of the SJC. Fourthly, the SJC is akin to a domestic forum and it conducts administrative proceedings regarding the question of conduct or capacity of a judge who is to be judged by his own peers. Fifthly, the finding of SJC are recommendatory in nature and do not enjoy the status.
So, yes, agreed. What is the point you want to make?
I'm trying to make here this a domestic forum. Your Lordship was saying that it's just like as if it is some kind of a rival court to Supreme Court. No, it is a domestic
No,
court.
it is not. It's a constitutional body.
It's a constitutional body.
So, what happened in this case? Why did you come to court? What relief did you get or not get?
इसका primary function जो है वो इंक्वायरी है।
नहीं, ये फैसला जो आप साइड कर रहे हैं, ये क्यों आया आपका केस सुप्रीम कोर्ट में?
ओपन इंक्वायरी
केस क्यों आप लाए सुप्रीम कोर्ट ये वाला?
ये इसलिए कि हमने कहा था कि इस केस में कि हमारी ओपन इंक्वायरी होनी चाहिए।
तो सुप्रीम कोर्ट ने क्या फैसला किया?
सुप्रीम जुडिशल काउंसिल ने कहा नहीं,
किधर?
शुड बी इन फोरम। इस केस में
फिर तो आप ये ग्रीवेंस दोबारा एजिटेट नहीं कर सकते हैं ना हमारे सामने।
नहीं, बात क्या हुई, इसमें उन्होंने अलाउ कर दी ओपन इंक्वायरी। दिस जजमेंट अलाउड ओपन इंक्वायरी सब्जेक्ट टू सर्टेन कंडीशंस।
वो पैराग्राफ किधर है?
जी वो उधर भी आ जाएंगे। इट्स ए वेरी हिस्टोरिक जजमेंट इन दैट केस में
कहते नहीं अलाउ हुई है। क्या फायदा?
वो वापस भेजा ना सुप्रीम जुडिशियल काउंसिल 577 पैरा 96।
वो एक
Consequently, the question regarding the conduct of proceedings open.
नहीं, तो ये तो वो रिमांड हो गया ना। ये केस रिमांड का केस है।
नहीं, इसमें उन्होंने कहा कि
नो आमिद खान साहब
सब्जेक्ट टू
हम जो इतनी देर से आपसे सवाल पूछ रहे हैं, ये पैराग्राफ 96 जो माय लॉर्ड ने पॉइंट आउट किया, सब पढ़िए।
नहीं वो ठीक है, उससे
आप पढ़िए तो।
सर बात ये है,
आप पहले पढ़े तो ना 577 पे।
Consequently, the question regarding conduct of proceedings through an open justice as requested by needs to be revisited and decided afresh by SAG, not standing uninfluenced by its order dated so and so. जो order set aside उन्होंने किया।
आप पढ़े ना।
In the light of the observations made here and above. In the light of the observations.
तो this is
observations क्या है?
एक सेकेंड
जी
सर, हमारी बात सुन लेना। अभी हम आपसे बार बार पूछ रहे थे रिमांड, तो ये रिमांड ही तो किया है।
पिछले सवालों का जवाब है
ये पहले सवाल का जवाब इधर मिल रहा है।
मैंने भी तो रिमांड ही मांगा है।
नहीं, मगर आपने बताया ही नहीं। आप कोई और वजह से बताया।
जजमेंट का मैं ये कह रहा था कि उसमें
फिर क्या किया सुप्रीम जुडिशियल काउंसिल ने इस ऑर्डर के बाद?
इस ऑर्डर के बाद उन्होंने अलाउ की थी इन दैट पर्टिकुलर केस अलाउड ओपन हियरिंग।
वो ऑर्डर कहाँ है?
वो कोई दूसरा रेफरेंस था?
वो दूसरा रेफरेंस 242 है।
अच्छा, ये केस नहीं।
जो इस केस में इम्प्यून था वो रेफरेंस 242।
लेकिन इस रेफरेंस की तो बेसिस जो है वो तकरीर है, और उस तकरीर को आप डिनाई नहीं कर रहे हैं, उसके कंटेंट्स को।
ठीक है, but then that has to be inquired into. तो मेरा गुजारिश ये करनी थी, जो जनाब के ऑब्जर्वेशन थी,
that reference was dismissed. What happened?
that was never decided.
You want that
ये proceedings take off.
You want that be also be decided. आप चाहते हैं कि उसको भी डिसाइड करें?
नहीं सर, बिल्कुल नहीं, इसकी बात नहीं। मैं तो आपके सामने आपका प्रेसिडेंट दिखा रहा हूँ कि प्रेसिडेंट ये है। फिर उसमें इंक्वायरी के तरीकाकार इसमें बड़ा अच्छा तरह डिस्कस हुआ है, वो भी जरा देख लीजिएगा। उसमें उन्होंने कहा कि ये जो इंक्वायरी होगी सुप्रीम जुडिशियल काउंसिल की, उनके ये पैरामीटर्स होंगे। मैं उसकी तरफ जनाब की तवज्जो दिला रहा था। वो तो आखिरी में उन्होंने कहा कि जी ठीक है, रिमांड कर रहे हैं आप, इस जजमेंट की लाइट में आप डिसाइड करें। परफेक्टली ऑल राइट। वो एक पहला था, उसने कहा था इंक्वायरी में ये कुछ होना चाहिए।
खत्म।
जी सर, सो मेरी गुजारिश ये है कि all the judgments so far says that a judge cannot be removed on the basis of a report which is not based on inquiry. And this is the case without inquiry. The Supreme Judicial Council has submitted a report in which they have recommended the removal of the judge, and therefore that is clearly an unconstitutional void non-est order. About what Lordship was saying, उसके बारे में मेरी गुजारिश ये है कि प्रोसीडिंग्स में शोकॉस नोटिस हुआ एक, उसके 2 दफा, पहला प्रिलिमिनरी रिप्लाई फिर एडेड रिप्लाई ये हुआ। उसके बाद एक एप्लीकेशन मैंने दी जिसमें मैंने कहा कि अगर अव्वल तो ये एड्रेसिंग ए बार एसोसिएशन इज नॉट ए मिसकॉन्डक्ट, बट इन केस यू वांट टू होल्ड इंक्वायरी प्लीज होल्ड इट इन ओपन कोर्ट। वो जजमेंट वो भी मैंने दिखा दिया। उसके बाद उससे 2 दिन बाद जब हियरिंग हुई उसमें ये सारे सवाल आए और उसमें हमसे ये पूछा गया कि हाँ इंक्वायरी है, हमने बिल्कुल ये की है, ठीक है।
नहीं, एक सेकेंड। सो देयर वर 2 रेफरेंसेस, एक में अलाउ हो गई आपको ओपन और दूसरे में नहीं अलाउ हुई।
नहीं, दूसरे में तो
आपने कहा था, आपने दरखास्त दी थी ना ओपन के लिए।
सर वो तो ओपन क्वारी का तो प्रेसिडेंट बन चुका था, ओपन क्वारी का तो प्रेसिडेंट हो चुका था।
अभी आपने कुछ देर पहले कहा कि उसमें इंक्वायरी ओपन नहीं हुई थी, मैंने रिक्वेस्ट की थी।
उसमें नहीं हुई,
तो एक में किया और एक में नहीं किया,
इसमें नहीं किया।
और फर्क क्या है दोनों में?
फर्क ये है कि आफ्टर इसमें तो इंक्वायरी सिरे से नहीं हुई ना, उसमें
नहीं, मैं अब इंक्वायरी की बात नहीं कर रहा हूँ, मैं अब कह रहा हूँ प्रोसीडिंग्स के वो प्रोसीडिंग्स ओपन करें जी, वो इन कैमरा ना करें। एक में तो आपकी दरखास्त अलाउ हो गई जी, आप कह रहे हैं बिल्कुल, वो रेफरेंस नंबर 242 में, मगर इस केस में इसका रेफरेंस नंबर क्या था?
मौजूदा रेफरेंस।
हाँ, इसमें आपने कहा नहीं हुई,
इसमें तो इंक्वायरी नहीं हुई सर।
क्या इंक्वायरी इज अ सेपरेट थिंग, ओपन प्रोसीडिंग्स की बात कर रहा हूँ।
ओपन प्रोसीडिंग्स देखो, प्रोसीडिंग्स इंक्वायरी की होनी थी ना, इसमें सिरे से इंक्वायरी नहीं हुई।
नहीं, वो एक अलग पॉइंट है, प्रोसीडिंग्स ओपन हुई या नहीं हुई?
उस एप्लीकेशन पे कोई ऑर्डर नहीं, यानी जितनी प्रोसीडिंग्स,
इसका नंबर क्या है रेफरेंस का, ये वाली मौजूदा का?
347। जितनी
ठीक है, समझ गया,
ओपन नहीं हुई।
Got it. Can we ask Mr. Salahuddin? We want to wrap it up. Mr. Salahuddin, you've been hearing everything?
I was not able to meet to Islamabad because of lack of availability.
What is the way forward? Address that point only.
My Lord, my submission is that the report and the notification is to be set aside on the ground of being malafide in law.
Please tell us the way forward.
Yes, sir. My submission is that it cannot be remanded to the SJC. The SJC scope is limited under Article 209. However, this court, if it considers fit, and I would urge that it
Who do you represent? Who do you
factual merit.
एक सेकंड ठहरिए ना, who do you represent?
My Lord, the Bar Association, Karachi Bar Association, and the
So you basically you don't want the truth to come out.
No, sir.
Yes.
In fact, my petition.
No, you are saying. Please hear us. You are saying that the relief should be given to the petitioner, but the people of Pakistan should be kept in the dark because they can't handle the truth. So why can't it be remanded? Why are you saying it can't be remanded?
No, not at all, sir. I'm not saying that it should not be investigated. My submission is that the proper forum would either be this court itself or a commission appointed.
We are not seeking your opinion. We are seeking some legal response. In my opinion, that doesn't help us, does it? Why can't it be remanded?
It is because of the language of 209 itself, sir.
Where does it suggest that? In fact, Mr. Hamid Khan has just cited a case where it was remanded, the matter was remanded.
इसमें ये जो केस इन्होंने रेफर किया है इसको डिस्कस कराएं, page
cannot be remanded. If Mr. Shaukat Siddiqui was still now.
We can't, voice is gone.
48.
नहीं तुमसे पूछ रहे ना पढ़ेंगे ना
So the council recommend his removal. Therefore, it does not have then jurisdiction under 2096. So the remand right now cannot be done. It could have been done 2 years ago. But right now, the remedy is that uncertainty those allegations.
So you mean to say, on account there is a well settled principle that no one should suffer as a consequence of act of court. So you're saying because the court delayed the matter for 2 years, the petitioner's valuable right has been taken away from him. Is that your argument? We can't hear you. You're not speaking clearly. करें ना ठीक इसको.
That the civil servants actual tenure has been.
Civil servant को आपने जज बना दिया. अब आप please don't.
Disciplinary proceedings का principle तो वही है sir.
No, it's not. Please, no, don't do this. If you're reducing a constitutional office to the level of a bureaucratic thing and saying the same principle applies, with respect, I will not agree with you.
My submission is that the stigma around the person's reputation caused by wrongful removal, that is something that he is entitled to remove, even if he has finished his age of service. It is the same principle which your lordships entertain appeals against convictions, even when
Mr. Salahuddin, please, Mr. Salahuddin, please focus on the Constitution. With him, Mr. Ahmed Khan has read 2095, which says inquiry, then 2096, which talks about inquiry. And you are saying there's no need for an inquiry because he's retired, he's at age of 62. So even if SJC did not comply with the Constitution, so let him suffer.
What I am saying this court is to set aside the report of the Supreme Judicial Council and the President's notification on account of being without jurisdiction and
we are asking you, can it be remanded or not? We're not asking you, can it be set aside?
My submission is the reason the factual allegations cannot be investigated anymore by the Supreme Judicial Council is because
we should. Are you saying that we should take over the functions of the Supreme Judicial Council? That's the only solution. Then there's no other way. Either they do it or we do it.
The Supreme Judicial Council has a specific role.
Mr. Salahuddin, you're not providing us any solution. You are saying the Supreme Court should assume the functions of the Supreme Judicial Council.
Yes, sir. The Supreme Judicial Council will end if a judge, for whatever reason, is no longer there.
Then why are you saying for whatever reason we are dealing with a real case?
Yes, sir. He has crossed the age of superannuation.
So he should suffer. He should suffer because of that.
No, I'm not saying he should suffer.
I don't know.
I'm saying the order can be set aside
without conducting inquiry. We should set aside the order. Why?
The order should be set aside
without inquiry. No, without inquiry.
Irrespective of the merits of the case, the order is without jurisdiction, therefore it deserves to be set aside. It is without jurisdiction for 2 reasons. The first reason is that the inquiry was not initiated.
If you're arguing in this manner, what provision of law have you filed your petition under?
184(3).
What's the first word in that? Then you don't have a case. Then we should dismiss your petition on that ground alone, because you're arguing against your own petition now. You are saying you're now claiming the right of an individual and not the public's right. Please read 184(3). It starts with the word public importance. So you are now pleading the case of the petitioner, not the public's. You're not saying exactly what you're doing. You say public should not know the truth of the matter. Please give him his pension and that's it.
So we have two aspects of public
आप पढ़ तो लेना 184.3 पढ़िए ना जी.
So the first aspect of public importance is that whether the SJC has the legal right to remove judges without a factual inquiry. That is a question of public importance. The second question of public importance here, which is separate, is whether the allegations of Mr. Shaukat Siddiqui were correct or not. That has to be investigated separately. My only submission is that the SJC no longer can do so. The reason I am saying this is,
you don't, when you say a statement, back it up. That has to be investigated separately. I'm quoting your words. How? That's the only question we're asking you.
Your Lordships, in 184.3, your Lordships can...
I'm just quoting your words. Who will investigate? We. Say, tell us.
The truth of the allegations can be determined by this court.
So we record evidence. We will record evidence. We will record evidence.
There's no bar to it, sir. But if your Lordships feel that
feel की बात तो नहीं हो रही है. You're assisting the court. We don't go on feelings. Assist the court on the constitutional point, not on our feelings.
My lord, there is no bar under 184.3 to recording of evidence. It is done even in constitutional petitions under Article 199.
नहीं तो आप हमें वे फॉरवर्ड, हम बार बार पूछ रहे हैं ना, वे फॉरवर्ड बताएं.
गुजारिश ये है कि it may be referred to a commission.
Sir, if you can speak slowly, we can't hear your words.
माइक से थोड़ा पीछे हो जाए. माइक से थोड़ा पीछे हो जाए.
Ji, sir. My submission is that it may be referred to a commission that inquires into the factual truth or otherwise of his allegations. Because I completely agree that the allegations are of such a nature that the public has a right to know whether they are true or not.
Where does the Supreme Court have this power to appoint a commission?
My lord, the power is 184.3 and...
No, don't just say these things. No, read the language. Where does it say Supreme Court can appoint a commission?
Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article. Now,
please stop. Go to 199 and say as that the High Court can constitute a commission. If they can, we can.
My lord,
unless you want us to start writing into words into the Constitution, you can't just throw in something and say commission should be instituted. Commission, the only commission that I'm aware of is Commission of whatever Inquiry Act of 2017,
yes, sir.
Which the federal government constitutes. So where is the power of the Supreme Court to constitute a commission?
My lord, the mandamus would issue to the federal government.
अब आप कहीं और जा रहे हैं, तो आपकी प्रेयर में तो ये बातें हैं ही नहीं ना.
What do you say about 210? Article 210. जरा पढ़े.
For the purpose of inquiring into any matter, the Council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction shall be enforceable as if it had been issued by the Supreme Court.
What do you say about when in presence of such a vast powers, why you are reluctant to remand the matter to Supreme Judicial Council?
सर मेरा ये कहना है कि साथ में 205 और 209(6) भी देख लिया जाए. If on information from any source, the council or the president is of the opinion that a judge of the Supreme Court or a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity, may have been guilty of misconduct, the president shall direct the council to, or the council may, on its own motion, inquire into the matter.
That's a very point we've been saying. Inquire. Admittedly, SJC did not do that. And I'm not following you at all. You're not citing any precedent, or you are just saying, in my opinion, feelings. I mean, let's go on the Constitution. What does it say?
My Lord, the Constitution says that the SJC can inquire into the conduct.
Okay, that's the whole point. They did not inquire. That's the case. Hamid Khan's case is.
Yes, if I may explain, sir.
It's not an explanation. It's a fact. Either they did or they didn't. They did not inquire.
This is admitted fact.
Sir, if the SJC report and the president notification is set aside, does Mr. Shaukat Siddiqui automatically become a judge of the High Court? No, he does not. And because he does not become a High Court judge, then the SJC cannot inquire.
At least he will get the status of ex-judge of the High Court. Former
Sorry?
judge. He will get the status of ex-judge of the High Court.
Exactly. And there is nothing in 2095 that allows the SJC to inquire into the conduct of an ex-judge. Then if your lordship sees 2096 has to be
there's a settled principle of law. When a list comes before a court, it has to be decided at what was there at that time. Not aaj law ye ho gaya. Suppose a crime is created today, we will not decide it as today. We will decide it when the law was at that particular time. It's well settled principle. Unless specific retrospectivity is given to something. So merely saying these things, we can simply avoid what you are saying, that the list before the SJC, we are considering matters, we're going back, traveling back in time. Whether time has moved forward or not, whether he's attained the age of 65, 62, are all subsequent events, coincidental events, which one view is they are very material, that the minute the watch goes forward, 62 is struck out of court. I gave an example, you were not listening maybe, that before he could file a petition, the next day he retired. So he has no remedy, then you can say, yes, he has no remedy. Let's at least be on the same line. I mean, then I can appreciate it if you use the same logic. But you're simply saying because he's retired, that's it. So then he's condemned. You can drag on proceedings, you can curtail a proceeding.
That is the opposite of what I am saying. I am saying that if a person retires...
But we are not talking about if a person, we're talking about a judge. This is not a bureaucrat here before us. Let's use the word judge.
Right. If a judge retires, and your lordship comes to the conclusion that the SJC order was without jurisdiction.
We are not saying that. No. We are not saying that at all. You've not been following. We are simply focusing on one point and one point alone. No inquiry was held. Without jurisdiction, we are certainly not saying, yes, Supreme Court had jurisdiction.
My humble submission is that the lack of a factual inquiry renders those proceedings forum non juris and without jurisdiction. If there are factual aspects that have to be looked at into, and the domestic forum or the SJC doesn't look into it, then that renders the decision of that forum without jurisdiction and malafide in law. It is
this your you're arguing on the basis of a normal petitioner, then why should we entertain your 184(3) petition? Where is the element of public interest? We will concern ourselves with the petitioner, the judge before us. You have got no concern with the matter then. If this is your argument, if you merely want him, whatever, that the order set aside, how does it benefit or not, or how does it for independence of judiciary, transparency, right of information of the public, then you removed the entire public importance aspect of the case from your case. Then we should not hear you, we should dismiss your petition, we should just hear Mr. Hamid Khan. If you're taking away you're removing all the public element from it. If the public element is removed, then how are you invoking the 184(3) jurisdiction? The same question Mr. Khan has also come before us in 184(3). On the thing, it's not just me is independent of the judiciary. I mean, has the independence of the judiciary been restored because now he'll be entitled to pensionary rights? Is the truth not important anymore?
My Lord, it is certainly important, as I have said, but forum is different. But what I'm saying is the public importance is there because if the Supreme Judicial Council removes a judge of a superior court without holding a factual inquiry, then your Lordship has to declare that to be without jurisdiction.
You are repeating yourself. Then I don't think you're going forward.
Salahuddin Sahab, ये Supreme Judicial Council Procedure of Inquiry 2005, इसका Section 8 Subsection 7.
जी सर,
वो जरा पढ़े आप. Without prejudice to the foregoing, the Council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by Council to be just and proper in the circumstances. और उसके बाद मैं आपसे कहूंगा जरा पेज नंबर 48 पे इम्प्यून्ड ऑर्डर जो है इसका पैराग्राफ नंबर 15 पढ़ लीजिए जरा आप. पेज नंबर, ये हामिद खान साहब की जो पेपर बुक है इसका पेज नंबर 48 और पैराग्राफ नंबर 15.
जी सर,
ये पढ़िए जरा. आफ्टर हियरिंग द लर्नेड अटॉर्नी जनरल,
जी, आफ्टर हियरिंग द लर्नेड अटॉर्नी जनरल फॉर पाकिस्तान and Justice Siddiqui at his learned counsel and his learned counsel at great length, the matter was adjourned by the council to 8/10/2018 for deliberating upon the respective submissions and to determine the way forward, keeping in view the peculiar circumstances of the matter at hand. The council met again on 8/10/2018 and the entire matter was deliberated upon from diverse angles. It was pertinently observed by the council that Article 209(5) of the Constitution of the Islamic Republic of Pakistan authorizes the Supreme Judicial Council to inquire into conduct of a judge of the Supreme Court of Pakistan or of a High Court upon a direction of the President of Pakistan or on basis of an information received from any source or on its own motion, and Supreme Judicial Council Procedure of Inquiry 2005 prescribes the mode of conducting an inquiry.
तो पढ़ने दें इनको, पूरा मुकम्मल करने दें इनको.
I think, if your Lordship, if I may skip a few and go to the about 10th last line of the next page.
जी, आप 10th last line, 4th line से पढ़े. It was इनका जजमेंट का रेफरेंस दिया गया अभी जो हामिद खान साहब ने जो रेफर किया है इसके जजमेंट का रेफरेंस दिया है इसमें. ये पढ़े आप, इसी कंटिन्यू करें इसको आप.
जी सर, जी.
In the case of Justice Shaukat Aziz Siddiqui and
in the case of Justice Shaukat Aziz Siddiqui, the Supreme Judicial Council procedure of inquiry was held by the Supreme Court of Pakistan.
APLD 2018 Supreme Court 538 इसका रेफरेंस है. जी, कंटिन्यू करें.
जी, to be constitutionally valid and compliant with university accepted principles of due process. In the present matter, initial scrutiny of information was conducted in terms of para 7 of the said procedure of inquiry.
ये जो मैंने पढ़ा था.
A discussion and inquiry into the information was undertaken in terms of para 8 of the procedure of inquiry. A decision was taken to proceed against Justice Siddiqui and a show cause notice was issued to him along with the supporting material calling upon him to explain his conduct. And after receipt of his 2 replies, the council had met and they decided to proceed further with the matter in terms of para 9 of the procedure of inquiry. And thereafter, the Attorney General for Pakistan was required to conduct the proceedings in terms the para 10 of the procedure of inquiry. After that stage of the proceeding, the said procedure of inquiry remains silent regarding the procedure to be adopted or followed in a given inquiry, and the counsel is extended the necessary discretion to adopt any procedure which may be found by to suit the requirements of the inquiry. Such discretion of the counsel is manifestly explicit from the contents of para 8(7) of the procedure of inquiry, according to which, without prejudice to the foregoing, the counsel shall have inherent powers to adopt any procedure specific to the inquiry which is considered by the counsel to be just and proper in the circumstances. As the proceeding against Justice Siddiqui were based squarely upon the making of the above mentioned speech by him and the multiple and pervasive allegations leveled by him.
इसमें वो बताना चाह रहे सलाउद्दीन साहब इसमें बताना चाह रहे कि हमने इंक्वायरी कर ली है। इनका कहने का ये मकसद है कि इंक्वायरी हो चुकी है, हमने अपना प्रोसीजर अडॉप्ट कर लिया। आपसे एक सवाल, आपकी बात अगर तस्लीम की जाए कि इनके हद तक सेटिसाइड कर दें, इनका स्टेटस बहाल हो जाएगा, और दूसरी पोर्शन में जो इंक्वायरी आप कहते हैं वो अलग से कंडक्ट हो। सपोज हम आपकी बात मान लें, इंक्वायरी कंडक्ट होती है, उस इंक्वायरी में ये हम ही करते हैं और ये साबित होता है कि इनकी एलिगेशन गलत थी, फिर क्या होगा? इनका स्टेटस वापस लिया जाएगा? कौन लेगा?
Still, इसमें फिर ये होगा कि there would be it would be then before the relevant criminal court perhaps, because there would be a question of perjury, there would be a question of
Ex-judge of the High Court will face the criminal charge without the intervention of the Supreme Judicial Council.
My lord, judges are not above the law.
No, the Supreme Judicial Council, they have to face the consequences through Supreme Judicial Council.
My lord, with respect, if someone commits the act of criminal defamation,
no, we don't want these analogies which are not applicable to Supreme Judicial Council or to judges. Let's stay focused on the Supreme Judicial Council, on judges and the Constitution. We don't need any analogies. If you can throw any further light, please continue.
No. My lord, I'm not making an analogy with respect, because
please let it go. If you want to continue, we don't want these analogies.
My lord, this is what is the statement. If the statements are false, then it's not a matter of analogy, then there are consequences for false statements on both sides.
I don't. If I was to deconstruct what you're saying, first of all, it's a never-ending thing ever. Let's take logically what you're saying, as what my lord had put to you, that if the petitioners this order is set aside on the basis that no inquiry was held, and subsequently a commission, okay, it's magically formed, we go along with that, and the commission, where is the commission? It's not a court of law, it's not a constitutional body, it's a sub-statute body, naturally, or a body created by an order of a court. It can either be one or the other, not a third one. That finding will prevail over the Supreme Judicial Council, will prevail over the Supreme Court, and on the basis of this inquiry is held either pursuant to order of the court or the Supreme Judicial Council, a judge can go to jail for perjury. This is the sum total of the argument. I don't follow this.
Let me explain myself, sir. It will not, obviously, the commission, the report of the commission too, does not automatically affect.
First tell us who creates this commission.
It is formed under the Commissions of Inquiry Act, and if your lordship sees in the act,
so if a commission of inquiry determines something that this judge had not stated the truth earlier, he will be persecuted for perjury.
My lord, it prepares a report. That report is then forwarded to the relevant body.
आप ये बार-बार ये चीजें कह रहे हैं ना, vagueness, relevant body. We are a highest court. We want to know what is this body. Each word you must.
The criminal investigation agency, sir.
So we are then handing over the fate of judges to some SHO or sub-inspector in police.
If if a judge makes a false allegation, he defames someone, commits libel, and it is found to be false, then he should not expect to.
Qazi Saab not quite getting traction with me at least.
209 के अलावा
कोई और बात करें या if you want to file refer to you are not sorry but you're not referring to any precedent, any law, I mean these are just opinions stated at the bar. कुछ और हमें बताए ना, कुछ चीज तो बताए ना, कुछ आगे बढ़ने वाली बात।
अगर आप इजाजत दें तो मैं थोड़ा सा ये जो पैसेज
आप ऐसा करें, आप अपना राइटिंग में सबमिशंस कर दें बिकॉज हमें समझ नहीं आ रही बात एंड वी आर मे बी यू हैव गॉट बेटर आइडियाज, यू कैन पुट देम इन राइटिंग एंड वी विल कंसीडर देम।
May I just summarize the...
No, please do so in writing because you will carefully think out everything and I'm sure it will be, because if it's also 10 minutes to 2, आप हमें writing में दे दें, we will certainly consider it.
जरा आर्टिकल 2095 मैं पढ़ना चाहता हूँ। ये कह रहा है कि इफ ऑन इंफॉर्मेशन फ्रॉम एनी सोर्स द काउंसिल और द प्रेसिडेंट इज ऑफ द ओपिनियन दैट ए जज ऑफ द सुप्रीम कोर्ट और ऑफ ए हाई कोर्ट मे बी इनकेपेबल ऑफ प्रॉपरली परफॉर्मिंग द ड्यूटीज ऑफ हिज ऑफिस बाय रीजन ऑफ फिजिकल और मेंटल इनकेपेसिटी और मे हैव बीन गिल्टी ऑफ मिसकंडक्ट, यानी कि 2095 का ए या बी दोनों में से कोई एक भी अगर अप्लाई करेगा तो 209 अप्लाई कर जाएगा, यानी कि लफ्ज इन्होंने और इस्तेमाल किया है लॉ मेकर्स ने। बात हुई इंक्वायरी के हवाले से तो बड़ी बात हुई और हमने नोट भी करी, लेकिन मिसकंडक्ट के हवाले से कोई एक बात भी कोर्ट में नहीं की गई। टॉकिंग फॉर माई सेल्फ, ठीक है
जी सर।
तो मिसकंडक्ट के हवाले से अगर देखा जाए तो ये जज साहब जो थे जिन्होंने जो बातें तकरीर में करी हैं, डोंट यू थिंक दैट दिस फॉल्स अंडर द एम्बिट ऑफ मिसकंडक्ट एज पर आर्टिकल 2 जो कि कहता है कि केयरफुल टू प्रेजेंट डिग्निटी ऑफ द कोर्ट, और आर्टिकल 9 जो कि ये कहता है कि ही शुड वर्क फॉर द इंटेग्रिटी ऑफ द इंस्टीट्यूशन ऑफ जस्टिस। नाउ व्हाट आर द इंस्टीट्यूशन ऑफ जस्टिस? इंस्टीट्यूशन ऑफ जस्टिस आर हाई कोर्ट्स एंड द सुप्रीम कोर्ट्स। तो इन दो आर्टिकल्स के हिसाब से आपका क्या ख्याल है कि ये जो पिटिशनर साहब हैं ये मिसकंडक्ट के जुमरे में नहीं आते हैं? अगर थोड़ी देर के लिए हम मान भी लें कि इंक्वायरी वाला एस्पेक्ट जो है वो रह गया था सुप्रीम जुडिशियल काउंसिल से, लेकिन ये जो एस्पेक्ट मिसकंडक्ट का है वो स्क्वायरली अप्लाई नहीं करता है क्या पिटिशनर के केस के अंदर, स्पेशली इफ व्यूड अंडर आर्टिकल 2 एंड आर्टिकल 9 ऑफ दीज रूल्स? तो इस एस्पेक्ट के ऊपर हमें कोई असिस्टेंस नहीं मिली है माजरत के साथ। इंक्वायरी के हवाले से तो जरूर हमें मिली है कि ये इंक्वायरी नहीं हुई और इन लोगों को बुलाया नहीं गया, लेकिन वी हैव नॉट बीन प्रॉपर्ली असिस्टेड, टॉकिंग फॉर माई सेल्फ, विद रिगार्ड टू द एस्पेक्ट ऑफ मिसकंडक्ट जो कि आर्टिकल 209 के बी के अंदर फॉल करता है और जो कि साफ साफ कहता है कि अगर मिसकंडक्ट होगा तो आर्टिकल 209 लगेगा। इसके बारे में आपका क्या?
Should have been leveled, you were seeking publicity. So anything else you want to say, please do so. Otherwise, this will be, we'll consider it reserved. ठीक है, लिख लें आज कोई है लिखने वाला ऑर्डर, आप इसमें लिखें। 2 weeks time.
Sir, I need only 1 week to have a comprehensive note on.
आप देखिए, आप आजकल जरा बहुत सारे केसेस आ रहे हैं, all of them require a lot of thinking and detailing. तो we'll certainly give you more than a week. I mean, it's not that. इसमें लिखिए, we've heard the notices were issued to general Lieutenant General retired Faiz Hamid and Brigadier retired Irfan Rame, and
he's not retired, my lord. We corrected that. He's still in service.
Okay, and Brigadier Irfan Rame, and is still a brigadier or is
he's still a brigadier?
And Khwaja and senior counsel Khwaja Haris has entered appearance on their behalf and states that he's filed CMA numbers 267 and 268 of 2024 attending to the allegations leveled against them by the petitioner. So full stop. Learned Senior Counsel Mr. Wasim Sajjad states that he represents Justice Muhammad Anwar Qazi, former Chief Justice of the Islamabad High Court, and has filed CMA number 253 of 2024 attending to the allegations pertaining to him.
3 CUS filed.
हाँ? एक से काम नहीं बना वसीम सजाद साहब चलें वो लिख लीजिए फुल स्टॉप notice was also issued to the former registrar of the Supreme Court of Pakistan Mr. Arbab Muhammad Arif who has filed CMA number 270 of 2024 ठीक है full stop next paragraph लिखे we've heard Mr. Learned Senior Counsel Hamid Khan for the petitioner and Mr. Salahuddin Ahmed for petitioner in CP number. आपकी कौन सी है Salahuddin साहब? हाँ? 15 आपकी CP का नंबर क्या है?
I'm sorry, my lord.
What's your CP number?
15 of 2020, constitutional petition.
15 of 2020.
20.
एक और भी है apparently. And two CPs number 2 and 15 of 2020.
221 की है
अच्छा 221 की अलग अलग नंबर चेक कीजिएगा प्लीज ठीक है फर्स्ट ऑफ वी आल्सो हर्ड मिस्टर Learned Senior Counsel Messrs. Wasim Sajjad and Khwaja Haris और कोई तो नहीं यही सब हो गए फुल स्टॉप and the Learned Attorney General for Pakistan full stop assisted by मलिक जावेद असिस्ट किया था या उन्होंने आपको असिस्ट किया अच्छा मलिक जावेद फुल स्टॉप नंबर ऑफ फुल स्टॉप असिस्टेंस इसमें लिखिए लीगल लर्नड काउंसिल में सबमिट देयर concise statements. Written synopsis. Precise. My lord adds precise and concise. Statements with regard, amongst others, to the following queries which arose during the hearing. Colon. फिर आप इसको 1, 2, 3, 4 कर लें. Whether an inquiry was conducted by the Supreme Judicial Council, and if not, was it a constitutional or legal requirement, and if it was, the consequences of the failure to do so. Question mark. Whether, if the consequence of doing so. Number 2, लिखें. The consequence, इसमें लिखते हैं whether that since in the interregnum, that since during the pendency of CP number 76/2018, CP number so and so लिख दें, was filed on कौन सी तारीख को फाइल हुई थी? 76
October 2018.
वो डेट ले लीजिएगा, 18 October 2018, and the petitioner attained the age of 62 years
30th of June 2021.
on 30 June 2021, comma, the whether what if any what can now how can the matter now be attended to if the petition is to be allowed, okay, if he is to be granted allowed, if he is to be granted relief, whether including whether the matter can be remanded to the Supreme Judicial Council. Anything else? Whether there was no need to conduct an inquiry by these SJC, as the speech admittedly given by the petitioner in itself, making of the speech in itself constituted misconduct as defined in the judges, वो पूरा नाम लिख दीजिए, code of conduct. ठीक है? Anything else you want to add?
Sir, in addition to response to these questions, I may kindly be allowed to give the propositions, my propositions.
हमने लिखा amongst others, वो बाकी आप जो मर्जी लिखना चाहें, मगर ये चीजें अटेंड कर लें. अच्छा, full stop. हाँ, प्रेसिडेंट्स भी दे दीजिएगा, हमें लिखने की जरूरत तो नहीं है ना.
Everything.
ठीक है.
Comprehensive.
So these three you attend to, the rest whatever you want to add, we are not stopping you, but just keep it sort of more precise. Not, it shouldn't be legal drafting. It should be point. Thank you. Chale, thank you very much. It's been a learning experience also for us. तो ख्वाजा साहब, अच्छा हाँ, कितने within how much time to be given आपको?
I think 2 weeks. If your lordship wants.
हाँ,
It's up to you.
3 हफ्ते दे दें आप. नहीं, ये legal issues है ना.
Quite right.
You know, we don't want to say something ना. अब इतना वक्त गुजर गया तो 1-2 हफ्ते अगर वो हमारे खान साहब नाराज ना हो, कल ये 3 हफ्ते अब दे दिया. ठीक है, खान साहब 3 हफ्ते ठीक है? 3 हफ्ते ठीक है?
सर 2 हफ्ते ही काफी होंगे सर.
तो ख्वाजा साहब 3 मांग रहे हैं, 3 कर लें. वैसे भी ये इलेक्शन वाला हफ्ता तीसरा हो जाएगा ना फिर. ठीक, हाँ, तो ये इलेक्शन के बाद ही जाएगा मेरे ख्याल में. अच्छा, इसमें लिखे कंसाइज स्टेटमेंट्स टू बी फाइल्ड विद इन 3 weeks. In case after judgment is reserved, however, in case after examining the concise statements and the available record, a further hearing is required, the court will convene. We don't know what you're going to say, and some of the things I have not read that were filed today and yesterday.